the first part of the presentation is not necessarily substantive. So if there are folks who join later, they can catch up pretty quickly. So again, this is the Office of Open Government Board of Ethics and Government Accountability Training for the Office of Unified Communications, or OUC. This is our FOIA training, effectively managing the Freedom of Information process. So the presentation will proceed in this manner. First, I'm going to discuss an introduction to the Freedom of Information Act, and then I will go into responding to actual FOIA requests. I will next go to conducting searches for records in response to a FOIA request, producing records, and then we'll go over actual decision letters. So I don't have this slide here. It's at the end, but I just want to introduce us again. We are the Office of Open Government. We are office within the Board of Ethics and Government Accountability. It is our charge to advise on the implementation of FOIA. So to do that, we have training obligations along with the Executive Office of the Mayor. And we also provide advisory opinions upon request on Freedom of Information Act issues, and we advocate for government transparency in general. So FOIA is really the mechanism that most people know about that facilitates government transparency. So we look to have a informed citizenry, and they are able to be informed about the operations of government through requesting records. That's one means that through the Freedom of Information Act, that they are able to see what the government is doing, see our records, and keep us accountable. So, the DC Freedom of Information Act, or FOIA, is a DC law that gives the public the right of access to information from the District of Columbia government. Under DC FOIA, the DC government must release information that is requested unless that information is protected from disclosure. Now, we also, under FOIA, as a government, are required to proactively provide certain information without a FOIA request. So most agencies, and I believe including OUC, have a tab that is the Open Government tab, and that information is included and should be updated regularly, the information that is required to be published without a FOIA request. When we were in person, physical copies of that information could also be provided to a person upon request. So they don't have to go through this formal process that I'm going to go through with you today. So there are categories of records that we just need to have available. DC law requires that the information is available upon request and online. And again, listed on the agency's website under the FOIA tab. So after this training, you may want to check your FOIA tab and make sure the information I'm going to go through is there. If it's not updated, make sure that if you have a webmaster or someone who is connected with the Office of the Chief Technology Officer can make those updates for you if necessary. And also, as you all know, we have data sets and data that's available on opendata.dc.gov. So FOIA information may be there. So we also recommend to you in the course of FOIA requests that you direct FOIA requesters to these online sources because that information that they're seeking might be located here, and it might be easier on the FOIA officer to just point to a website or a web page as opposed to going through this entire process. So I just got a message that you may have lost me briefly, and I said before, if something happens where you can't hear me or my connection is bad, let me know, please, orally, because I probably won't be able to see it if I have a bad connection. So I'm going to turn my video camera off to make sure that you all can clearly see the presentation. It's a better picture of me anyway. I couldn't dress up for you guys. Today is Monday. Sorry. All right. So I did have this slide here. So it's about us. So again, we are the Office of Open Government, OOG. We advise the entire district government on FOIA. So we also advise the public on FOIA. So anybody who wants to know about FOIA, we'll provide that information. Um, as director, I, and as well as my colleagues who assist me, we can expounds on an issue through an advisory opinion. So that's like a written legal opinion about a FOIA issue. Our FOIA opinions are not binding, meaning that they're not mandatory. You don't have to follow our advice, but we do provide well-researched um, FOIA opinions so that you can be aware of what the law is and you can share that with others. And we serve as an advocate to ensure the FOIA process is fair and executed properly. So part of what we do is train agencies on the law. So we hope that, through this training today, you'll be better equipped to respond to FOIA requests. And also, if you do ever have a requester who comes to you and they really do not know or understand the process, we also help them as well. So you can always point those people to our office, and we are able to assist them with actually filing their FOIA request, because there may be some conflict of interest with you doing that as well. But you can always be helpful, and we encourage you to do so. But people's other responsibilities may make it difficult to do that. So you can certainly send them our way. So FOIA, who's who? DC FOIA management. As you all may know, there is no central body within DC government that handles FOIA requests. Each DC government agency is responsible for processing its own records. So it is responsible for processing FOIA requests that it receives. The primary point of contact for DC FOIA is the agency's FOIA officers or the agency director. And you may have more than one FOIA officer, since some agencies do, and that's not uncommon with a larger agency that has a lot of records. So there may be a FOIA officer, and then there may be assistants. And the general counsel's office also can provide assistance to the FOIA officer, but the FOIA officer is the person who responds to the request and makes the decisions about the records. The DC Mayor's Office of Legal Counsel handles DC FOIA appeals, and the DC Office of the Attorney General handles FOIA litigation through the Civil Litigation Division and provides FOIA advice as well through their Legal Counsel Division. So we have a lot of resources to help, and a lot of hands, I guess, in the FOIA process. So just to go back, so the primary contact is the government agency, and then when you go to the appeals process, it is the MOLC. And then if it goes to DC Superior Court or further litigation, the Office of the Attorney General represents the district, will be representing the district agency. Now, the DC government also has an open government advisory group. This group advises the mayor on open government issues, including FOIA, changes to the law, and things of that nature. The group includes subject matter experts from the district government and also from members of the public who have expertise in open government. Now, each agency, as far as their responsibilities for FOIA, must designate a FOIA officer. So an individual within that office must serve in the capacity as a FOIA officer. The FOIA officer is usually appointed by the director of the agency or by the general counsel of the agency. And each agency must post on its website the name, title, address, and telephone number and email address of its designated FOIA officer. And the regulations, the FOIA regulations, 1 DCMR sections 401.2-401.3 dictate that this information must be available to the public on the website. We also keep that information, but it is most helpful if agencies comply with the law and make sure that that information is on their website. The agency's FOIA officer is the one who conducts or coordinates a reasonable search for records, and they are the person who responds to the FOIA request timely on behalf of the agency. So now I'm going to go into actual meat of the Freedom of Information Act. So we're going to start with what is considered a public record. So DC FOIA requires that the government must provide access to public records to maintain openness and transparency in its government operations. So we're going to look at what is a public record that is covered under FOIA, and this is something that is defined by the DC FOIA law. So DC FOIA and DC Official Code Section 2-502, subsection 18, and I'm starting there because this is what we most deal with these days. Public records includes information stored in an electronic format. So now, as we are partially remote, and have gotten a lot better at using technology to do our business as a government, the records that we create on our computers that we're creating today via WebEx in this recording and other types of information that are not traditional tangible records are records, public records under FOIA. Now, the traditional definition of public records includes, is also a catch-all, includes all books, papers, maps, photographs, cards, tapes, recording, vote data, including ballot definition material, raw data, and ballot images, or other documentary materials, regardless of physical form or characteristic, prepared, owned, used in the possession of, or retained by a public body. So basically everything that we create as a government that is in the course of our government business that doesn't fall within an exception is a public record that may be subject to the Freedom of Information Act and a Freedom of Information Act request. So keep that in mind as an agency, as you are determining how to maintain your records, what your filing system is. So you keep that in mind. It's just a good business practice so that when these public records are requested, it's a more seamless and easy process to produce and find those records. So some contractors' records, I know we do a lot of business with DC government contractors. Some of those records are included in records that need to be released to the public under FOIA. So so DC Official Code Section 2-532, subsection A-3 includes records produced or collected pursuant to a contract with a private contractor to perform a public function. So that's very specific. So if you have a contractor who is essentially doing something that a DC government worker or employee would be doing, and they're kind of stepping in our shoes, then those records are produced or collected are also included in what is considered a public record. So that's something to make contractors aware of. But again, it's when they step into those shoes of the district government and a function that we would be doing without them. So as I mentioned earlier, our websites on the FOIA or Open Government tab, I think most are labeled Open Government and FOIA. And also these should be kept in physical form or can be kept in physical form. So these categories of records are available without a FOIA request. So that means that, as I go through the FOIA process and what that looks like, what a FOIA request looks like, it doesn't apply to these records. You should just have them ready for the public to view without a FOIA request. So should just be available as a matter of course. So the first is employee salary, title, and employment dates. There is on the DCHR website a large list of all of our names, hire dates, as well as our salaries. Most pages just connect to that document. Um, it might be helpful to know on what page of that document your information resides. So if you're asked, you can tell them that pretty quickly. And there's a search feature within that document that you can tell them about where they can find a particular person or a particular agency. Contract expenditures, again, you can either post those yourself. Generally, the Office of Contracting and Procurement also keeps that information. So linking to their website to the specific page where they provide contract expenditure information may be something that you can do on that page. Budgets, that's usually, again, that's something that you should have, that your agency director should definitely have, that can be published. You could publish a budget page that comes after the council, the District of Columbia Council and Congress approves the Budget Support Act. So that's a record that should be available. Now, these are definitely agency specific, so you would have to extract these records from your own records. So manuals, policies, rules, opinions, orders, and meeting minutes of open proceedings of public bodies. So that's another part of our responsibility. Now, we do have enforcement responsibility for the Open Meetings Act, and these meeting minutes are something that we look at if there's a public body that is subject to the Open Meetings Act, as well as FOIA. This information should be made available, and the agency that is servicing that public body should have those records available on their website. Now we're getting into the actual FOIA requests and the FOIA requesters. And if there are any questions at this point, let me know. I don't see anything in the chat, so hopefully everything's making sense. So the first item here is who may request records. Well, anybody can request records under FOIA, and that is anyone, anywhere. So any person has a right to inspect at his or their discretion or to copy any public record of a public body except as expressly provided in the DC FOIA exemptions, which we will go over. And we do get requests from folks outside of the United States. So the next slide is how requests may be submitted. Now, this is, again, exclusive of the list I just read previously. All other records, someone has to submit a FOIA request. So a request for a record of an agency may be made orally or in writing and must be directed to the particular agency. And all these are found in the FOIA regulations. A requester may be asked to submit in writing a request for records, and requests may be mailed, faxed, or emailed. So sometimes you may have a situation where someone calls in and asks for certain records. So you can tell that person, hey, I need you to send me an email so I know exactly what you're asking for. So you can ask them to put that in writing for you. Or you can do that for them and send it back to them via email. So you just have a record of what the FOIA request actually was. Now, the regulations, again, and it's good to go over them, that talk about FOIA is one, DCMR section 400 plus. It contains all the rules and procedures to be followed by all agencies, offices, and departments of DC and all persons requesting records pursuant to FOIA. And those can be accessed at dcregs.dc.gov. So it's important that when you receive a FOIA request, you know what the person wants. So a FOIA request, the law requires it to be specific. So the regulations say that a request must reasonably describe the desired records. If possible, specific information regarding names, places, events, subjects, dates, files, titles, file designation, or other identifying information shall be supplied. And that is in 1 DCMR section 402.4. I like to look at it as if someone lost their keys. They would be able to tell you details about those keys so you can find them. They will be able to tell you what color keychain may be on the keys. They'll be able to tell you what color the keys were, how many were there, where they lost it, when they lost it. So they need to be able to give you specific details so that you can find those keys or find that record. So you don't have to go on a wild chase for any and everything. They need to be specific so that we as the government are being efficient and not wasting our time. So the next item in the presentation is responding to the FOIA request. Now, we will walk you through that. I mean, I think this is probably the main event for government. And I'll say at the outset, all of this revolves around communication. And it is not unreasonable for you to contact, as I'll discuss, a FOIA requester about their FOIA requests, and we encourage you to do so because that helps to make them feel heard, to know that you are on it and responding, that something is happening, that they're just not kind of out there. So the first step in the DC FOIA process is to acknowledge receipt of the request via email, message, or other initial communication to a FOIA requester. And we have an automated system, which you may be a part of, FOIA Express, and the public may use that to make the FOIA request, and you may use it to process it. So all these things are automated when you use FOIA Express. However, it may be good to go out of the system and let them know who you are as a FOIA officer, give them your contact information so that they have a real person to respond to. That sometimes that's just good customer service to do it that way. Even if everything will be taken care of through the system, you can also chat with them in the system, but letting them know that there's a real person who's there responding to them and looking for records, I think is helpful to, again, to our public, and then also to showing that we are a transparent government. So the initial response will include an introduction or acknowledgement, any clarifying questions if you need them, a discussion of FOIA fees, if you have a type of request that you think that there will be FOIA fees, a processing track designation. So sometimes there's a number assigned, the number usually assigned in FOIA Express automatically, but some agencies have their own numbering system. Contact information for questions, then of course just our general customer service salutations as we do in the district government. Sincerely, your signature, name, agency, and title. So our response times. Our response time for anything other than a body-worn camera is 15 business days. For a body-worn camera, it is 25 business days. And these are calendar days, so you don't count holidays or weekends when you're doing the count to determine when you must respond to a FOIA request. In FOIA Express, again, this is automatically baked into the program. Now, you may extend the time to respond to the FOIA request for 10 days if there are unusual circumstances. So you invoke the 10-day extension by giving written notice to the person who requested the documents and letting them know the reason for the extension and when they can expect to hear from you and will have a determination regarding their FOIA request. Now, the circumstances are defined by the DC code. So it's not just that I'm overwhelmed, which we all are, and I don't have time to do this. There are specific circumstances under the DC code, section 2-532, subsection D 2A. So the first is the need to search for, collect, and appropriately examine a voluminous amount of separate and distinct records that are demanded in a single request. And I'll say at the outset, emails are generally one request that can fall in this voluminous amount, because usually when you have an email search, it may take a while for the Office of the Chief Technology Officer to provide you with the responsive emails, and then there just may be a lot of them that you have to review. So also in that case, you're going to want to definitely reach out to the FOIA requester and work out a schedule with them. And I like to advise in that instance to try to get at least the first batch to them by, which would be if you invoke the extension, the 25-day period of time with the extension, to try to get them something. But you may not be able to, just may not be possible. But again, that's where that communication comes in. And B, also is the need for consultation, which shall be conducted with all practicable speed with another public body having a substantial interest in the determination of the request, or among two or more components of the public body having substantial subject matter interest therein. So I know with your agency, with Office of Unified Communication, you sometimes have investigations happening and you have to confer with the Metropolitan Police Department on some issues. So that is considered a circumstance, an unusual circumstance where you have to confer with another DC government agency about that request. So you can invoke that 10-day extension. And you should. And again, body-worn camera, the inability to find a vendor that's able to perform redactions within the 25-day period. That is another reason to invoke an extension of time. Again, we know in working with contractors, they're not always on our same timetable and can have the same turnaround. So the FOIA law has permitted an extension for that purpose as well when you're dealing with body-worn camera footage. So what is the consequence of not responding to a FOIA request on time? The practical outcome of that is it's deemed a denial by law. So if you don't respond within 25 days, the requester has the right to appeal to the mayor, the mayor's office of legal counsel, or they can go to DC Superior Court. So another question that we often get is, what if I receive a request that's overly broad? Well, the DCMR provides that a request shall reasonably describe the desired record. Where possible, specific information regarding the names, places, events, subjects, dates, files, titles, file designation, or other identifying information shall be supplied. So what does that mean? So that means from a practical standpoint, if you don't know what they're asking for, or if it's just so broad that they want kitchen sink, you can ask them to clarify their request. You can say, hey, I can't find that. There's too much, or it's too broad for me to be able to locate a record. The good thing about that is once you make that request to them to narrow the request, the clock stops until they actually provide you with information that will facilitate you being able to find that record. So there's nothing wrong with asking a requester to clarify their FOIA request. So this is that information where, and it's in 1 DCMR section 402.5, and it states where the information is supplied by the requester is not sufficient to permit the identification and without the location of the record by the agency, without an unreasonable amount of effort, The requester shall be contacted and asked to supplement the request with necessary information. Every reasonable effort shall be made by the agency to assist in the identification and location of the requested records. So what is meant by this is, again, we want that communication to happen between the requester and the agency. So it may just be that that person doesn't quite know how to ask for a record. So they're just asking you for everything. I want all emails received between person X and person Y in 2022. Okay. That's a lot of emails. I'm sure you don't want to hear about the church picnic that happened 2 Sundays ago. So let's kind of narrow it down and see what you're looking for. So that's completely reasonable for you to say, well, let's narrow down some dates. So I see a question from Heather. How long should we keep the clock stopped for? It stopped until they respond to you. I think we have said that you can do an administrative closing of the request if they never respond back. So we have some times where we have requesters who give these blanket requests to the district government. So they'll ask, make a broad request, and they'll add everyone, including the federal government. And this is probably an extreme example, but it illustrates the question. So I think we have said 3 months. And Cherie Barry is our FOIA officer. You can chime in, Cherie, if we've stated a specific time. But then you write them a letter, but pretty much give them a warning, say, hey, I'm going to close out your request if I don't hear from you in a certain amount of time. I'm going to assume that you no longer want this information. And then after the time you state, which might be 7 days, 7 business days, you close that request. So there's no official way, I guess there's no regulation that defines it, but this has been our recommendation, because just being in DC and being the district, we do get a lot of requests that are really not intended for us. So this is how we've handled it.
Niquelle, I'll just add, you are correct that we don't have any regulations or anything legal for a specific time period. But what I would suggest is that, whatever time period you give them, make sure you have that documented and give them multiple attempts, usually around 3 times, I think would be sufficient, over a 3-month period, like Niquelle said, or a couple of weeks, or whatever time period it is. Make sure that you have that documentation. So if they come back and say that there was no contact or no response, you'll have that to say that you at least reached out and tried to communicate with the requester.
Okay, thank you, Cherie. Go ahead, John.
Also, Niquelle, if I can add to what Cherie said, I think it's been our practice to also advise that we let them know when basically they've abandoned it, that they can resubmit a request in the final notice.
Yes, that's always a good idea. Again, making sure they're made aware of their rights, and that, again, we're open. We're not trying to hide the ball. Just like, hey, we didn't hear from you, so we just want to make sure you're still here before we do all this work. We're trying to make sure you get what you want. I mean, so that's kind of the spirit behind it. But thank you, Johnny and Cherie, for that clarification on that question of the time period. So we've kind of gone over that. So this is, again, the deadline. How does it, but what's the impact? So 1 DCMR section 405.6 provides that a request is deemed received when the designated FOIA officer or agency head, in the absence of the designated FOIA officer, receives the request submitted in compliance with the Freedom of Information Act. So the start date if you didn't go over. So when the start date is when the FOIA officer receives it. So back when we were in person, let's say theoretically someone came and hand delivered a FOIA request to the secretary who's at the front, or the front office staff person. So the FOIA request is not deemed received until that mail is opened and that is delivered to the FOIA officer. It's usually not a big deal now, because a lot of things are done electronically. So it's usually you get it through FOIA Express or it's through email. But the official start date is whenever the FOIA officer or the agency director receives the FOIA request. Now, again, when you contact them, the clock stops. So the new start date is whenever you resume again. So let's say in our example, you do have kind of a more, I'm gonna call the other one illegitimate, but you have a FOIA requester who is able to narrow it down to say, no, you know what? I just want emails between person X and person Y. There was a meeting that happened on January 20th, and I want to have their emails that were a week before and 2 weeks after that meeting. So you say, all right, that's better. I can find those records. So let's say you receive that on X date, that's the date that the clock starts again. So in FOIA Express, you would go and I think there's literally a button for you start the clock again. If you're outside of FOIA Express, then that's when you start your clock date and do your count for the 15 business days is after that date that you receive that information to clarify, so you're able to actually start conducting the search. And again, the thought behind it is you need to be able to, again, find those keys. So if you don't have the right information, you can't even start looking for them until you have them described to you in a way that you could actually find something. Now, unfortunately, our federal partners are able to reject a request that is overly burdensome. We in the District of Columbia government are not able to do that. So there's no authority to treat a burdensome request as void. So we do have a lot of FOIA officers. So a lot of our laws do pattern after federal FOIA. This is not one of them. So if you are looking at a case or something of that nature or information that talks about an overly burdensome FOIA request being rejected, that's just not something we can do in the district. Now, searching for records. So once we have the official start date, we can conduct a search for records. So we're all, oops, I went back, sorry. Let's see, we'll go back. There we go. So all agency employees who maintain records must assist the FOIA officer to identify records that are responsive to a FOIA request. So the FOIA officer is not just out there by themselves. It is everyone's responsibility to look for responsive records. If the FOIA officer comes to you asking you, hey, do you have XYZ record? Or, hey, there was someone, an email that was yours. Now, Octo keeps all of them, but it might just be easier. Hey, do you do you have these emails that you sent to such person? And they might be able to find them. So it's not an unreasonable thing for a FOIA officer to ask an employee to do. And we're all responsible for assisting the FOIA officer if we maintain a record with producing a record, and for searching for the record. So in assessing whether a district agency has conducted an adequate search in response to a FOIA request, the courts are going to look at the fruits of the search, not at the fruits of the search, excuse me, but they're going to look at the appropriateness of the methods used to carry out the search. So the issue to resolve is not whether there might be any other existing documents that are responsive, but whether the search was adequate. So we're going to talk a little bit about an adequate search. And these things, again, come up because the remedy for a FOIA denial is to go to court. The district government always needs to be prepared for that. And we need to have within our FOIA programs mechanisms that demonstrate that we conducted FOIA searches that are appropriate to be able to identify those records that were requested. So the courts have gone on to say that it doesn't need to be a perfect search, it just needs to be adequate. And again, reasonableness of effort in light of the specific request is what the court will consider. So a search must have been reasonably calculated to uncover all relevant documents. So one of the things that we recommend that you do within your FOIA program is create an affidavit of the FOIA officer's attempts and the agency's attempts to search for a record, or also do a declaration. So the difference between an affidavit is a declaration that is notarized. A declaration is just a statement of facts that is signed. The reason that we make a recommendation for you to do this is, again, people move on. There might be turnover. So the person who did this search may not be with the agency. So it's good to have that. Also, as a matter of litigation, when you're in court, there's something called like a present sense impression. So it's closer to the actual event, because when these things go to trial, or go to court, it takes a while instead of litigation for it to actually be discovered in discovery. So if you have something like a declaration or affidavit, then you don't really have to figure it out at the time. Well, what did I do? I can't remember what I did. It's all written down. So if a requester challenges the adequacy of the agency's search, and again, summary judgment. So that's a judgment on the pleadings. The agency in DC has to be able to establish beyond a material doubt that it expended these reasonable efforts to uncover all relevant documents. And setting forth this type of information in affidavit for a court to determine if it's adequate is just a good practice. And then you see the case that's there that we get that information for. So again, we recommend that as a matter of business practice, the agency consider having the FOIA officer do this declaration or affidavit, just to setting forth what happened. So it'll provide, so what should my affidavit or declaration include? It'll provide context for the request. So that means describing the structure of your agency's file or record keeping system. It could be electronic or paper. So a lot of us have like a shared drive or files that we use now. So that's our record keeping system. So an affidavit could include, hey, I did a search for XYZ terms, or, I had my staff member do a search for those terms on his email or on his drive to find these records that you requested. Another thing that comes up that you may want to address in a declaration or affidavit is, do we have a retention policy? We all should have a record retention policy, but again, that makes things easier for you because when you dispose of a record pursuant to your record retention schedule and you send it to archives, you can send the FOIA requester to archives if archives has those records. So if they, for example, ask you for a record or recording that is from 2005 and pursuant to your record retention policy, you have sent all those records to archives, you are able to send that FOIA requester to archives. What happens over at archives is archives will assert whatever defenses or things of that nature that may apply, but they are the ones who are the custodian of the records. So the affidavit would state something like that. Hey, this record was pursuant to our record retention policy. I did a search. It was I talked to our records officer. It was sent to archives. So I am sending you to archives for that record. So was a search conducted even if the retention policy called for disposal of the record? So that's again, you would say yes. And we even looked in our files to make sure we did not send it, that we might have a copy. So uh, employee X, she looked in this drive and for that document, and she realized, given the date, that it had been sent to archives. So again, when I don't know if you all have been involved in litigation, but it's much easier to look back at something that you've written than to really just remember it because, hey, life happens. So the agency must describe at least generally the structure of the agency's file systems, which makes further search difficult. So again, if you said, hey, we've done all we can do, we don't have this record, putting that in the affidavit stating why just makes your case stronger for an adequate search. And again, I'm focusing on this search because this is just part of the process that you need to bake in so that if it's ever questioned, you knew you've done it properly, you have it put on in a document saying what you did. That will just make it easier for you in the long run. So again, that explanation, how was the agency search? Was it reasonably calculated to uncover all relevant documents? Why was the search conducted that way? How was it conducted? If only one system was searched, make it clear that this system was the only possible place that responsive records could be located. So email searches, that this is how we are doing business now. And it is a very difficult process going through these electronic records. So it might be if you have a huge request, the courts have said we have to look through these. We have email, we have a catalog from I think 1998 to now. So we can't, the court has said, DC, you can look through these records, you have them, you can look through all of them. So again, as I said earlier, the process now is you go through OCTO. OCTO is going to send you a file that contains the emails you've requested based on search terms. And if they're large and voluminous, like 20,000, 50,000 emails, someone has had to go through those. So the court has not excused us of an obligation of doing that. So the search is actually conducted by OCTO. So as part of that declaration or affidavit, you may want to address the process that actually happened, not what's supposed to happen, but what actually happened when you contacted the Office of the Chief Technology Officer for those emails, what search terms you had them use, how long it took them to get them to you, just going through that whole process so that when a court or an independent body looks at that information, they'll say, oh, they did all they could. So we don't think that there was any misbehavior on behalf of the district. And this goes to also for any other mediums, for audio recordings, for video recordings. We are keeping a lot of data as the government, and the Office of the Chief Technology Officer sometimes is the third party that is the warehouse. So we always look at OCTO as the warehouse. So we are as the agency is the owner. So sometimes the warehouse, it takes, just like in life, it takes a varying amounts of time to get the information to us. So make sure you document that. So the whole process for why did it take me a year to get my FOIA request filled? Well, here's why. So I have this written out so you can see the process I went through. So again, we're trying to show that we acted as reasonably as we could, because again, most of the time, FOIA officers, this is not your only job. I know most of you do the best you can, but again, making these documentations of what you did will serve you well in the long term. So again, for email requests, make sure that you explain, as I just did, how many email accounts exist within your agency and the district, and Octo's capacity in terms of searching for them. And you may, depending on the amount of records, you could request that Octo also submit an affidavit or a declaration about their process and how it actually compiled those records for you. Again, and this is something that you may particularly want to do if it's a controversial matter. You may want to make sure that you have Octo's declaration as well. So fees. So we can charge fees for search and duplication of records. So make sure that each person in the agency who's assisting with the search keeps a log or record or somehow documents the amount of time they spent searching for records, because the regulations literally set a dollar amount for that time, so that dollar amount can be passed on to the requester. Note that there is no fee to submit a FOIA request. However, you can advise a FOIA requester at the outset that they may be required to pay fees in advance if they have not paid FOIA fees in the past. So one good thing about FOIA Express is you can look through the system and see a FOIA requester and see if they have not paid fees, and you can hold the process until they pay those past fees. That does not mean you have to stop your process completely, but so this applies to you releasing the record. So you may charge fees for conducting searches and actually producing the records. So and they may ask you for the record in whatever medium they would like it. But there may be a fee attached to it. And you look at the DCMR, it'll show you that schedule of fees. And when there is no dollar amount set forth in the DCMR, you can pass on the actual cost of the duplication to the requester. You may grant what is a public interest waiver of fees. That is something that the requester must ask for, and you evaluate that based on the type of requester that they are. And usually that comes from journalists, those public interest waiver requests, or from researchers with universities. Those are the instances that I see justified ones. So examples of fees, I'm searching for records and reviews of records. Again, hourly rate based on the pay grade of the personnel who performs the search. Photocopies, 25 cents per page. Document certification, $1 per document to certify a document as being a true copy of an agency record. Again, the direct cost of any service or material for which no fee has been established. A requester may have to pay search and or review fees, even if the search does not locate any responsive records, or if the records are located but are withheld as exempt. So producing the records. So this is when we are at the finish line and we are making a decision, we being the FOIA officer and the agency. Now, as I've mentioned a couple of times, there are exemptions. So you don't have to produce everything, especially if it falls under exemption. So the exemption of under the DC Act are patterned on or have been construed in accordance with the federal law. So you may have instances when you need to go to your general counsel or the lawyers in your office and ask them about exemptions, and does this fall under the exemption? So a lot of the times you may see a federal case cited, and that's why, because DC law and federal law, except in very specific cases, usually are run parallel and are the same. So we can rely on that body of law. So the first exemption is trade secrets. So trade secrets and commercial or financial information obtained from outside of the government, to the extent that disclosure will result in substantial competitive harm, substantial harm to the competitive position of a person from whom the information was obtained, the information may be withheld from disclosure. The second exemption, we see this one a lot, is personal privacy. This is information of a personal nature where the public disclosure thereof would constitute a clearly unwarranted invasion of personal privacy. And I would say also we do a separate training on exemptions if that's something you're interested in. I think we do have that video. I can provide that training. But the personal privacy exemption requires you to do a balancing test. And again, the one who makes the ultimate decision is the FOIA officer. The FOIA officer must perform a balancing test under this exemption. The individual's privacy interest in the material at issue must be balanced against the public interest in disclosing it. And this public interest must serve the core purpose of shedding light on the agency's performance of its statutory duties. So here's some examples from cases about the balancing test. So in re appeal of Washington Post, the privacy interests of students and teachers under investigation for the consumption of alcohol substantially outweighs the public interest in their identifying information. In re appeal of Walter Thomas, may disclose names, professional qualifications, and work experiences of successful job applicants, but refuse to disclose other private information such as home telephone numbers and addresses, social security numbers, marital status, and personal references, or any information regarding unsuccessful job applicants. Exemption 2A, body-worn cameras. Any body-worn camera recording by the Metropolitan Police Department that was made inside a personal residence or related to an incident involving domestic violence, stalking, or sexual assault, as defined by the DC Code, is excluded from disclosure. Exemption 3 is the law enforcement exemption. Investigatory records compiled for law enforcement purposes, including records of counsel investigations and investigations conducted by the Office of Police Complaints. Now, let's see, I see there's something in the chat here. Sorry, I'm sorry, taken care of, sorry. So law enforcement records. Now, I will put a caveat to this because some of these may be changing with the new criminal code, but this is what the law exists right now. So exemption 3, disclosing investigative techniques and procedures not generally known outside the government or that would endanger the life or physical safety of law enforcement personnel. That is another reason for withholding a record. So that's exemption 3, the law enforcement exemption. Exemption 4 is agency communication. It is interagency or intra-agency memorandums or letters which would not be available by law to a party other than an agency in litigation with the agency. So I'm just going through these again. Exemption 5, future examination test questions. That's pretty self-explanatory. Exemption 6, other statutes, cannot be a regulation. Information specifically exempted from disclosure by statute other than FOIA, provided that such statute requires that the matters to be withheld from the public in such a manner as to leave no discretion on the issue or establishes particular criteria for withholding or refers to particular types of matters to be withheld. Going through exemption 7 through 9, that's national security matters under federal law, antitrust investigation, and arson investigations. 10 through 12, 10 is emergency response plans, 11 is social security and federal employee ID numbers, 12 whistleblowers unless the name of the employee is already known. 13 through 15, Homeland Security records, sealed criminal records, critical infrastructure. It only applies to entities regulated by the Public Service Commission, like Verizon, as one, Washington Gas are examples. Teacher evaluations are exempt from disclosure. And our traditional legal exemptions, attorney work product that applies to documents prepared by or for an attorney in anticipation of litigation, no matter the status or stage of litigation. Attorney-client privilege, it protects confidential communication between an attorney and a client when the agency is a client and the privilege is necessary to obtain legal advice. Deliberative process privilege, the method through which an agency creates policies, opinions, rules, and regulations. To qualify for this exemption, a record must be both pre-decisional and deliberative. Pre-decisional documents are those generated before the adoption of agency policy. A document is deliberative if it is a part of an agency give and take process by which the decision itself is made. Third-party communications, the deliberative process privilege does not generally apply to communications that include third parties. And again, this applies only to intra-agency documents. Communications that include third parties may be withheld under deliberative process privilege under the consultant corollary if the third party has no independent interest, their interest is aligned with the government. It may be withheld under this exemption. So the typical case is where the court applies the consultant corollary. So the consultant does not represent an interest of its own or the interest of any other client when it advises the agency that hires it. The consultant's only obligations are to truth and its sense of what good judgment calls for. And in those respects, the consultant functions just as an employee would be expected to. So we talked about that earlier. So again, this is another situation, is similar to the contractor situation, where the person is stepping in the shoes of the government. So the government itself can exclude documents from the consultant based on deliberative process. So I see a question, are drafts of policies, procedures, drafts that would that be considered deliberative? I would say yes. Generally, the final documents are the actual records. So as you are that back and forth that's happening within an agency, those are not things that would have to be disclosed. You would have to disclose whatever that final policy was. So yes, you could withhold that under the deliberative process privilege or exemption, and that would be permissible. So you usually don't see this. This is more so for the federal government, but I mean, since you all are law enforcement, you might apply the GLOMAR response. Acknowledging the existence of a record itself would divulge protected information. So the response here is an agency can neither confirm or deny the existence of responsive record. So a search may not be required if all potential responsive records are entirely protected. So again, this is something, again, that usually would apply in a national security context. So you would have lawyers advising you on making this response. And again, because the district's relationship with the federal government, this could, in theory, be something that you might encounter. So producing the records, the FOIA response does not have to provide answers to the requester's questions disguised as a FOIA request in response to an individual's request for information. The agency's obligation in meeting a FOIA request is to provide access to records. So you might see someone send you a FOIA request and it's just a list of questions. This is another example where you can have them redefine the request, but you do not have to just answer questions. You can refer that to your public information officer or to your legal department or someone else, but it's not to be handled under FOIA. You do not have to create records. So FOIA does not require you to create anything. You're just looking for records. So if you don't have a record, you don't have to produce it. So someone might say, hey, could you just give me a spreadsheet that lists your activities on XYZ date? If you don't, if you have that spreadsheet that you created in the course of business, you're not obligated to do that. So record redaction, how to perform reasonable redaction. So this is going to come into play when one of these exceptions that we just went over apply. So a record may only be withheld within its entirety if the agency determines that the record cannot be reasonably redacted. So a document may contain parts that are protected by privilege and parts that aren't protected. So the existence of the privileged part cannot be used to justify withholding the non-privileged portions if reasonable redaction is possible. So with respect to redaction, that the code covers that. DC Official Code Section 2-534, subsection B states, any reasonably segregable portion of a public record shall be provided to any person requesting the record after deletion of those portions which may be withheld from disclosure pursuant to subsection A of this section. In each case, the justification for the deletion shall be explained fully in writing, and the extent of the deletion shall be indicated on the portion of the record which is made available or published, unless including that indication would harm an interest protected by the exemption made in subsection A of the section under which the deletion is made. If technically feasible, the extent of the deletion and the specific exemptions shall be indicated at the place in the record where the deletion was made. So from a practical standpoint, if you could physically see a document like this one that's before you, I would be blacking out, let's say, the whole first paragraph of B, and I would have beside it the section of the DC code and the exemption that I used to justify blacking it out. So that's what that means from a practical standpoint. So questions to ask yourself when redacting. So 1, am I withholding an entire record? Are parts of the record not privileged? And 3, if I remove the privileged portions, is the document still legible? So question 1, am I withholding the entire record? So did the search find responsive records? If the search yields nothing, then you're not withholding a record. You're just saying, hey, I didn't find anything. Is the requester receiving everything found? If the requester got everything found, you're not withholding an entire record. So if you have a phone log and there's no privileged information in the log, it's just a bunch of numbers, then you're just releasing the numbers. You didn't redact anything. Are parts of the record not privileged? So your agency is withholding an entire record. What's the basis for withholding it? If you were to pick a random part of the record, would that basis be applicable? If yes, it's proper to withhold the record in its entirety. If no, you should be redacting and producing the record. So again, so if it's a random part of the record and you have the personal privacy exemption and whatever's in that record would violate personal privacy, then it's proper to withhold the whole thing. But if not, if you look to another section, oh, there's nothing to do with privacy, then that's when you would be redacting. So does the entire record raise privacy concerns, like a tax return, or only parts, for example, a work email that has a postscript about a medical procedure? So redacting the personally identifiable information may preserve privacy and permit you to release a redacted record. So again, it's just going to depend on the type of record, and you have to do that analysis to figure it out. So question 2, are parts of the record not privileged? Are you withholding due to attorney-client privilege? So you have to ask yourself there, is all the document embraced by that privilege? Was the part of the communication shared with a third party? So if it was, then that destroys the privilege. Is the entire reason deliberative process? Does the entire record raise privacy concerns? Again, just going over that again, looking at the factual information, charts or graph. Was it shared with a third party? You need to ask those types of questions when determining whether to redact it. Is the entire document part of the deliberation, or are parts of it definitive statements of already established policy? So just about the question we have about drafts, that's clearly it's the whole thing. So are there notes on the side, things of that nature? There's no way to release that document without violating the privilege. So, are you withholding due to commercial interest? So again, would the release of the entire document cause harm? Or would only the release of the dollar amounts cause harm? So let's say you had a contract bid and you received information as part of that bid. So would just revealing the information in of itself violate the commercial interest? Or can you redact the name out? Can you redact the dollar amounts out? And the rest of the document would not violate the commercial interest. So those are the types of questions that you need to be asking as you're going through this process. So a big question is, if you remove the privileged portions, is the document still legible? So non-exempt portions of a document must be disclosed unless they are inextricably intertwined with the exempt portions. So if you redact all the exempt portions, would you be looking at a wall of black ink? If so, you don't have to engage in redaction. I have seen that before. You all may have seen those examples where someone has a full black page with like one word that's legible. You just might as well just withhold the whole thing. I wouldn't want to receive something like that. That just, again, just looks like a government that's not transparent. So are there 3 pages or 3 paragraphs that wouldn't be exempt, then you redact and release. So the idea is just, you have to be reasonable about this. We are mostly reasonable, but I have seen a full, just blacked out whole page with one word. Just don't release the document in that case. So
I'm sorry, can I ask a question about that? This is Heather, and I think this is just a little too much for chat. We have had a lot of FOIA requests for January 6th.
right.
And we did get a appeal, and so we were told to do that. I mean, we literally provided a document to the appeals office that had the date and the time on it, and literally everything else was redacted. So is that something that we should not do that until, like, maybe we deny it and then the appeal process comes through and then they tell us to do that, or should we do that in advance and have that document ready?
That might be that's something we should probably consider outside of this training.
Okay.
Just given the nature of it.
Okay.
But my first thought initially is, if the court has already ordered something, to just to the extent that you can comply with the court order. At that point you're in litigation, so you should have OAG advising you. There should be an attorney from that office who's working on the case, who should be providing advice on these issues. So from a general perspective, so before you get to that process, before you get to a case, the advice I'm giving you applies. So, but
Okay.
once you're in the litigation process, that process is going to dictate how things look. So once the court is involved, yeah, things get a little more complicated, and you got a lot more lawyers involved, as you know.
Thank you so much.
You're welcome. Johnny, did you have something to add? Did I hear you?
No, that was not me, Niquelle.
Oh, okay. Did I hear someone else? Does anyone else have anything to add or ask? Okay. All right, I'll move on to scoping. So once I've identified a responsive record, can I redact information within the record that's non-responsive? So that's called scoping. So please don't do that. Once the government concludes that a particular record is responsive to a disclosure request, the sole basis that you can withhold information is on one of these exemptions. So that means discrete information within a responsive record cannot be redacted on the basis of non-responsiveness. So going back to that church picnic, so if it's an email where there's relevant information, you're talking about, hey, I'm going to church picnic at 4 o'clock after the government information was discussed. Do you want to come? You don't redact that information, just everybody gets to know about it, because we know as government employees, if you're talking about your personal life, it's not personal, it's it becomes a part of the government record. All right, the last part is decision letters. I know we're going a little over, and I thank you all for bearing with me, but we're almost done. Decision letters. What is required in an agency decision letter? So a decision letter should have in it whether the record was released in full, partially released, which is redaction, or withheld in full. The name and contact information of the person that made the decision concerning the release of the records, that's usually the FOIA officer, a reference to the DC code provision, that's the basis of the decision, and a statement advising the requester of their appeal rights. So decision letters do not include language that's not clear. So don't say something like, if it's construed as a denial, you're denying. So make sure it's accurate. So don't withhold multiple records using multiple exemptions with a single omnibus long sentence. So just make sure that you're clear, that these are examples that you should not do. Agencies withholding all responsive records pursuant to exemptions 1, 2, and 3. Again, that's not clear as to which exemptions apply to which records. So the requester, it does have a right to know that. So you should identify which exemptions apply to which records that you're withholding. So don't use that boilerplate or catch-all. Don't exert an exemption when you haven't done anything, when you haven't conducted a search. That's not proper. Don't ignore requests for months and then rely on appeals based on a constructive denial to notify that you're late. So make sure that you're up on that you're checking FOIA Express. And do not wait to identify overly broad requests. If a request is vague or overly broad, request that time as soon as you recognize the vagueness or broadness of the question. All right, so we've reached the end. If there are any more questions that you have, please ask them now. And we'll wait and see. Does anyone have any questions? Please unmute yourself or put them in the chat.
I don't have any specific FOIA-related questions now, but can we get a copy of this presentation?
Yes, absolutely. So after the presentation, I will forward you the slides, and we will also let you have a recording of the training as well. And this last slide here is our team, our small but mighty office. So anyone on this list here can assist you with any FOIA issue that you may have. If we're ever in the Bay Area building, we are located on Suite 540 South. There's usually someone there, I think every day but Friday. We telework, everyone teleworks on Friday. So if you're around, come see us.
Thank you so much. Would you also send us the recording for the exemptions? Or is that something that we need to actually participate in training for receive?
Yeah, well, we'll be happy to give you that training, but I'm happy to send you the recording. I'll send you both.
Okay. Perfect. Thank you so much.
Oh, you're very welcome. And thank you all for your attention. Sorry, I went over a little bit. But again, if you have any other questions or you need help with anything, we're here for you. So you're not out here alone. And again, thank you for service and all that you do for the district government. It does not go unnoticed. I know you are one of those agencies that does get a lot of volume with FOIA. So we're very happy to help.
Thank you,
Thank
Director
you.
Allen, and
Thank
we
you.
appreciate you all so much for all of your help as well.
You're very welcome. Okay, so with that, we'll adjourn, and I hope you all enjoy the rest of your day.
Thanks, you as well.
Okay,
Too.
bye-bye.
Bye-bye.